So what is it like to be a patent attorney day to day, and what is the work that we're doing on a day in and day out basis? People are always curious about that, whether it's people who are aspiring to be patent attorneys or patent agents, or whether it's even clients who want to know, it's like, hey, what are you doing on a regular basis? You know, when I call you or I email you, what is it you're typically doing? Okay, so it helps to sort of start with, what is the patent process like? Now, there are two ways to start the patent process. One is by filing what is called a non-provisional patent application. Now, this is the traditional patent application you think of that you file at the United States Patent and Trademark Office. It waits in line for 1 to 3 years before examination begins. The examiner picks up the application and looks at the claims to determine whether what you have is new and non-obvious compared to the prior art that is out there. That being any sort of technology that exists, whether it's issued patents, pending patent applications, products that are already out there, scientific papers, any sort of technology disclosure. The question is what you have in the application, is it new and non-obvious compared to that prior art? And that starts the negotiation of the examination process. And it's really important to think it as a negotiation. It's not just, hey, you have a patent or you don't. What you're trying to do is you're trying to get the broadest scope possible of your patent claims. And that's an important thing to consider as well, is that patents aren't just a binary thing where you have a patent or you don't. You can have a really broad patent that covers a lot of different things, or you can have one that is so narrow and so specific that it's really easy to get over just by making little changes and anybody can design around it. And that's determined during the examination process, okay? So you can have claims that are really broad or ones that are really narrow, and that's that negotiation. Just like, for instance, in Pawn Stars or American Pickers, where people haggle over price on something, you're trying to argue and say, hey, I deserve this broadest protection possible that covers a lot of different variations. And the examiner's saying, well, I want you to have as broad a protection as possible, but it still needs to be new and non-obvious over the prior art. And so there's that battle, between you and the examiner. Hopefully, in the end, you're able to convince the examiner that what you have is new and non-obvious. The application is allowed, you pay an issue fee, and the application issues as an enforceable patent. Okay, so when it comes to what patent attorneys do, patent attorneys will deal with both aspects of this patent process. One is going to be planning the patent portfolio, drafting patent applications, and filing them at the United States Patent and Trademark Office. So, of course, it can be that, that non-provisional patent application like I was talking about, but there's also the option of filing what's called a provisional patent application. Provisional patent application is almost by default used by startups, and I think that's a great way to start the patent process. So with a provisional patent application, you file the provisional patent application. It's just a placeholder. It is not substantively examined. It lasts for only 1 year. It expires automatically at the end of that year. That term cannot be extended. And that's when you have to file that non-provisional patent application that I talked about. That's the one, again, that waits in line for 1 to 3 years. Examination begins, and then it can be another, sometimes, it could be a few months, or it could be even years of that examination negotiation. So again, what patent attorneys tend to do is going to be all the parts of this. It's going to be planning patent protection, drafting and filing provisional patent applications or non-provisional patent applications. And then when the examination process comes up during the non-provisional stage, 1 to 3 years after filing that non-provisional application, patent attorneys will do that negotiation with the patent examiner. So what do these things really look like, and how are you doing this stuff? So when it comes to drafting applications and planning patent portfolios, what patent attorneys tend to do, their clients are going to be inventors, entrepreneurs, and startups, and maybe big. And this could be big companies. This could be small companies. It could be garage inventors. And for me, my practice is all over the board. A lot of my clients are Fortune 100 companies, but I also represent garage inventors, startups, and all sorts of folks in between. So a lot of the interaction you're going to have with people is going to be with engineers or scientists, whoever's developing the technology. That tends to be a lot of the people that you're going to be interacting with. And it depends on how big the company is. Sometimes, if it's just a startup inventor, it's just going to be them and maybe 1 or 2 of their partners if they happen to have those. At a large company, for instance, they'll probably have an in-house patent attorney who is, dealing with all sorts of patent applications. Usually there's going to be hundreds, if not thousands, of patent applications. They deal with broad strategy, and they'll kind of coordinate you with drafting patent applications and sort of planning the patent portfolio. But in the end, you're almost always going to be talking to some sort of engineer or scientist. At the same time, for startups, for instance, you're going to be talking with people who are entrepreneurs who may not have a technical background, but are still going to be the people who are on the business side, and you have to interact with those folks. Those tend to be the main people that you're going to be talking with at those initial stages. It's going to be the technology people, maybe in-house attorneys if it's a large company, and maybe people who are sort of like the business folks as well. And what you're going to be doing is you're going to be talking about the technology. As a lot of it is really having to understand technology on a really deep sort of level. And that's why patent attorneys have to pass what's called the patent bar. And the patent bar, one of the things, to sit for the patent bar, you have to have a technical background. Unlike sitting for the bar in one of the states after you've gone to law school, the patent bar requires you have to have a technical background in something like, say, computer science or electrical engineering or biotechnology, something like that. You have to have a technical background, because in these conversations with these inventors, you need to understand the technology as well, sometimes if not better than them. And so it's a very technical kind of thing to have these discussions talking about what is the technology and how are we going to protect this with patent applications. That's sort of the planning stage. Then it comes to drafting and filing patent applications. So patent applications are very detailed technical disclosure. In a lot of ways, patent attorneys are glorified technical writers. Like for me, I work at home a lot, obviously because of the whole, situation these days, and just the way that, my practice tends to be. I sit at home, my cat's around me, I'm binging on Netflix or listening to music, and I'm just doing technical disclosures about things like robots or heat exchangers or cloud computing, about little mechanical products, consumer products, things like that. So I'm working at home a lot, and I'm drafting very technical, detailed disclosures about technology. I'm helping to draft drawings and label those things, and getting into the gory details about how this technology works, whether it be how physical things are put together or how software works, sort of the algorithms, the processing that goes on with a computer to enable things to work. And that's a lot of what patent attorneys do, is drafting these detailed descriptions. Sometimes they can be short, they can be like 10 pages, but it's not uncommon for them to be 50 pages, upwards of 100 pages. So it is a lot of writing when you're drafting patent application. There's a lot of writing that goes on. And then kind of, sort of the sort of the day-to-day stuff is a lot of emails as well. I mean, that's the reality of things. I'm writing a lot of emails to clients, other attorneys that I may be working with, but there's definitely a lot of email communication. That's one thing to understand about patent attorneys, is it's a lot of writing. Realize that you're going to be writing technical disclosures that are going to become patent applications, but then you're also going to be emailing people a lot. And the environments that these sort of patent attorneys work in, it can be like me, where honestly, like, I work at home and I'm pretty independent and I don't see a lot of other people. Like, I can do stuff over Zoom. I've been fully remote for a long time and have minimal need to go into a physical office. Other people like to work in office situations, and it can be very, very collaborative in a physical kind of way, where you see people, close up and collaborate. But a lot of times it's not absolutely necessary as a patent attorney. You can do things kind of in stages, and you can coordinate with other folks, and it doesn't have to be in real time, via email or via calls or via Zoom. That's totally fine. So you can have different sort of patent attorney jobs. One that is like pretty much remote, where you're working at home, to being in an office full time or somewhere in between. So being a patent attorney can be fairly flexible. Okay, so that's drafting and filing patent applications. So with a provisional patent application, it can be a lot simpler. It doesn't have to be quite as technical. But for the non-provisional, those are very, very detailed patent applications. A lot of writing in those. And those are the ones that I said, maybe at the minimum is 10 pages. But typically it's going to be more in the range of, say, like 40, 50, upwards of, say, 100 pages. So you file that application, waits in line for 1 to 3 years, and then the examination process begins. So what is it like working with patent examiners at the United States Patent and Trademark Office? Okay, so what you start out the examination process typically by getting what's called an office action. And the office action, it asserts the rejections that the examiner has found against your patent application, usually saying, well, it's not new in view of prior art that I found, or it's obvious in view of prior art that I found, by kind of piecing things together. You take elements from one piece of prior art, you take elements from another piece of prior art, and then you kind of come to the invention that you have. Okay, so usually it starts with this office action. It's going to be a written thing that's mailed to you or emailed to you from the patent office. Okay, so there's going to be analysis that you have to look at the prior art, you have to look at your application, see what the differences are, and your options for a response to this office action. You can either argue against the rejections, or you can amend the claims in the application to kind of differentiate over the prior art. Okay, so when it comes to this analysis of things, again, it's a very technical kind of thing. You have to understand the description of the application and understand that in a lot of detail, but you also have to understand the prior art that is asserted against your application, and sort of do this analysis of, are the other rejections right, or are they wrong, and how, if they are reasonable rejections, how do we differentiate our application over what is cited in the prior art. So let's kind of step back and talk about the United States Patent and Trademark Office and how that works. So when you file your application, like I said, it goes in line, it gets filed, and it waits in line for 1 to 3 years. But what really happens is, so it gets assigned to an examiner, and it goes into the examiner's big pile of applications they have, and it finally kind of comes up until examination begins. So there are tons of examiners at the patent office, and they are segregated into what are called art units, and that's very technology specialties. And so even with, say, something like computers, there are tons of little specialty niches, so that each patent examiner kind of examines things that are very specialized to certain technologies, so they can become experts on that technology, but then also kind of experts on the prior art related to that technology. So they're kind of better, hopefully, at drafting rejections and kind of understand what is going to make things new and non-obvious compared to the prior art, because they sort of work in that sort of technology area. So the application gets assigned to a single examiner who's going to deal with it pretty much the whole way through examination. Now, the only time where you would get a different examiner is, say, maybe the examiner leaves the patent office, then it would be transferred to somebody else. But typically, it gets assigned to a single patent examiner, and you're really just dealing with that single patent examiner throughout examination, sort of throughout that negotiation. Sometimes if it's a new examiner, they'll have a SPE or a supervisory patent examiner who may get involved in calls on things. But a lot of times, even those junior attorneys or those junior patent examiners, they tend to work by themselves and won't always have their supervisor. So really, it's a lot of times it's just you and the patent examiner. And there's a lot of different ways that you can respond to the office actions you get, that being sort of the written rejections. One thing to realize, to note right off, is that these rejections are a natural part of the examination process. It's something to be expected, and is actually a beneficial thing. Just like, for instance, say like on Pawn Stars or American Pickers, where there's almost always going to be some haggling over price, right? The same thing it kind of happens in patent applications. You want to go in and you want to try to get the broadest claims possible, and the examiner is going to kind of try to pull that back and make sure what you have isn't new and non-obvious over the prior art. And just as, say, with buyer and seller haggling over something, coming to a price that makes sense for both folks, you can get to the broadest protection possible, and then the examiner will kind of push back on that and just make sure that you just barely get over that hurdle of patentability. So, this negotiation of going back and forth with the examiners, it's a natural part, expected part of examination. So, like I said, you get these office action with rejections. How do you respond? A lot of times it's going to be, it ultimately is going to be a written response, where you're going to have, like I said, you can have amendments to the claims, you can have arguments that talk about why the examiner is wrong or misinterpreting your claims or misinterpreting the prior art. But it's really important to also consider that you can actually talk to the examiner. You can schedule a phone call and talk about things, and that's sort of one of those secrets that people don't use as much as they should when it comes to the examination process. One of the best ways to get things allowed and to sort of expedite things is just talk to the examiner, because a lot of times they're not attorneys. They're people who have maybe an undergrad degree in some sort of engineering or science, and they're not people who are going to be confrontational. They want to help you out. They're technology people. Okay, so they're not going to be these people who are like, no, you can't get a patent. A lot of times they're friendly, and they don't want to be they don't want it to be a contentious relationship. And so if you go and you just talk to the examiner and say, hey, what do you think about making these amendments, or what do you think about these arguments, or here's how I'm seeing things, or maybe you're not quite understanding the invention. A lot of times it can really help to have a call with the examiner, and that can be a really important part of the examination process. But ultimately, it's going to be a lot of written stuff. So again, a lot of writing when it comes to to working with the patent office. Even you have to write these long written responses. So you have this initial office action, you file a response, has the arguments, maybe amendments, and then the examiner will go back, do another prior art search, and will probably issue another office action. They may find a new prior art, or maybe they disagree with what you said, and so the examination process continues. So it kind of has this back and forth. You get an office action with rejections, you respond to that office action with amendments or arguments. The examiner goes back, maybe reworks the arguments, and that'll go back. A lot of times it can be, I'd say 2 to 3 times. That's probably average to go back and forth with the examiner with this sort of office action response. And hopefully at the end of that, the examiner says, okay, I'm convinced. I haven't found any additional prior art. I'm convinced that what you have is new and non-obvious, and will give you what is called a notice of allowance, which means, okay, this is ready to issue as a patent. You pay a fee, and then the application will issue as a patent. Okay, so really there's not a lot of people who are involved in your day-to-day. It's going to be inventors, entrepreneurs, maybe in-house counsel for large companies. It's going to be patent examiners every once in a while. And a lot of times that's going to be written communication instead of on the phone, even though you do that sometimes. Those tend to be the main people. And also if you're going to be interacting with other attorneys, whether it be your supervisor, a lot of times there's going to be a partner at the firm who's going to give you work if you're a newer attorney. If it's yourself, maybe you won't have those people. But a lot of times people will have staff. You're going to have paralegals or secretaries, folks like that you'll be interacting with. And if you work in an office, it'll be a physical thing. But like for me, I have a lot of staff that have been in, say, like all the way in New York, and people who live in LA. I'm based in Seattle, and so I've never really met these people in person all that much. I've seen them in person maybe a few times. So it's something that potentially can be very work from home or work remotely, whereas other times it can be definitely an office culture. So it's sort of all over the board. Now, some of the things that patent attorneys do not do is, say, like patent litigation. Some patent attorneys do that. They make that part of their practice. Like for me, I do some consulting on patent litigation, but as far as like going to court, I never go to court. Last time I went to court was when I got sworn in to become an attorney, and that was it. So patent attorneys do not go to court. It's really not a thing that patent attorneys typically do, especially folks who are doing things like drafting an application, the examination process. It is not a court-based thing. Someone who is a patent litigator, they don't actually have to have passed the patent bar and have that technical background. A lot of patent litigators who will assert patents against people, sue people for patent infringement or defend against that, they don't have a technical background. They're just a regular attorney who went to law school and passed the bar in one state. Not to say that some patent attorneys don't do that. I know some patent litigators who are patent attorneys who have passed the patent bar, but that's not a requirement. Another place that patent attorneys can be found is, like I was saying, who are in-house patent attorneys, especially at really big companies with big portfolios of hundreds, if not thousands, if not tens of thousands of patent assets. There'll be an in-house person who is dedicated to doing patents in that company. And what that person tends to do is look at things from an overall structural perspective, plan patent portfolio, talk to the engineers at the company, and then coordinate with patent attorneys like me who work at a firm and help with patent protection. So that's a very different practice. A lot of times, especially at big companies, those people aren't going to be drafting patent applications. They aren't going to be the people talking to the patent examiner. They're not going to be writing the office action responses. They're going to be having the out-of-house, the people at the firms, the out-of-house attorneys, they're going to be the ones doing those sort of things. The in-house attorneys are going to be coordinating things, sort of more high level. At the same time, there are some companies where the in-house attorney, maybe it doesn't have such a huge patent portfolio that sometimes those folks will be drafting patent applications, so it may be sort of a hybrid thing. So there's a lot of different sort of, patent careers that you can have. And some people include a lot of other sort of things like licensing. They'll do licensing deals. They'll help out and consult with those things. And patents are one type of intellectual property, and so people will become intellectual property attorneys in general, even though they may be patent attorneys. They will help with trademarks or copyrights or trade secrets, doing those sort of things. So, there are some alternative things, but by and large, someone who is a patent attorney who practices as that, it's going to be planning patent protection, drafting, filing patent applications, and working them through the examination process. That tends to be the day-to-day of what a patent attorney does. So if you got some value out of this video, please give it a thumbs up. I'd really appreciate it. It helps motivate me to keep on making these videos and give out kind of free advice and things. And if you want more on patent attorney careers, or if you want more on how I help my clients protect their ideas and inventions and kind of the secrets on that, be sure to subscribe to the channel, hit that little bell icon so you don't miss any important videos. And yeah, thanks for watching. I really appreciate it. We'll see you again in the next video.